Hi folks, my name is Greg McLawsen. I am the Affidavit of Support lawyer. I have spent the past 10 years representing green card holders in federal litigation to enforce the USCIS Form I-864. If you are a sponsor, how do you terminate sponsorship under the Affidavit of Support? Well, the immigration regulations are actually very clear on this point. The sponsor has the opportunity to terminate or withdraw the Affidavit of Support only before the applicant, that's the foreign national, only before the applicant achieves residency status. Once an immigrant visa has been granted, or once adjustment of status has been granted, the Affidavit of Support can no longer be withdrawn. So once that foreign national has her green card, and even before that, once the adjudicating officer has actually approved her application, the Affidavit of Support is enforceable as a contract and it can't be withdrawn. Let's talk briefly about how you would withdraw it before that application is granted. The regulations say that whether we're talking about an immigrant visa at a consular post, or what's called a green card application or adjustment of status, or a USCIS Form I-485. These are applications filed within the United States. In either case, the Affidavit of Support can be withdrawn if the petitioner/sponsor makes that request in writing, and that writing makes it to the adjudicating officer. The reason that's somewhat tricky, let's take the case of adjustment applications. Those are filed with a service center that does the preliminary adjudication before it goes to a local USCIS field office. In order for a withdrawal to be effective, the request has to actually get to the adjudicating officer. So that can be complicated because I'm here in Seattle, let's take that as an example. If a green card application is going to the Seattle field office for adjudication, if the sponsor files the withdrawal request with the California Service Center, and meanwhile the USCIS officer here at the Seattle field office grants the adjustment application, that withdrawal wasn't effective because it didn't get to the right officer at the right time. So to be effective about this, you need to have some sophistication to figure out where the application is and where it's going. In the case of an adjustment application, usually the safest thing to do is to send the request both to the appropriate service center and then also to the field office that's going to have jurisdiction over the application. Similarly, with consular adjudications, these are immigrant visas through a consular post, it's safest to send the withdrawal requests both to the National Visa Center and also to the consular post that's going to have jurisdiction over the application. I have some instructions for this on our website. I'll go ahead and link that post in the comments to this video. 2 take-home messages. Number 1, the withdrawal request has to be in writing and made to the appropriate officer before the application is granted. After the application is granted, whether it's a visa application or a green card application within the United States, the Affidavit of Support is no longer withdrawable. It cannot be terminated after residency status is conferred to the immigrant. At that point of time, it is an enforceable contract. The obligations under the contract have commenced, and you need to be in defensive mode about thinking about how you're going to handle that claim if it's asserted by the I-864 beneficiary. Hope that's helpful. If you have questions, feel free to jump into the comments. If you are a beneficiary of an Affidavit of Support and you have questions about whether you have rights under the affidavit, reach out to us. We do video consultations all across the United States.